Hi, good evening. This is again a very interesting judgment from Bombay High Court. The citation is KMG Wires Private Limited versus National Faceless Assessment Center, Delhi. Income tax. The facts of the case assessment year is 23-24, 2023-24. AO assessed the total income of KMG Wires Private Limited. Hereafter, I will call it as KMG at rupees 27 crores. Declared income was around rupees 3 crores. KMG filed an appeal against this assessment order. It also filed a writ petition before the Bombay High Court. That is the interesting part. It filed an appeal before the appellate authority. It also filed a writ petition. Facts of the case are not very important as far as this case is concerned, but for the sake of completeness, I will simply put this way. Two additions were made by the AO. One is disallowance of purchases from a company. Since the department issued notice to that company, but that company did not reply. So on that basis, they disallowed the purchases made from that company. The second addition was made because it is in respect of peak balances in respect of unsecured loans from directors. So these were the two additions made. So AO issued notice. Reply filed by KMG was not properly considered. Order was passed. As already said, KMG filed an appeal and it also filed a writ petition. In the writ petition before the Bombay High Court, KMG said, My lords, I filed the appeal to say the limitation, but in case if this writ petition is allowed, I will withdraw the appeal filed before the appellate authority. So the appeal was filed only to save limitation. This was the submission. Then Bombay High Court heard the case. Bombay High Court said assessment order was passed in breach of violation of principles of natural justice. It noted from the writ petition, from the paper book, with regard to disallowance of purchases, the reply filed and evidences produced were not considered by the AO. In the reply affidavit, in fact, an apology was tendered by AO for not considering the reply. With regard to addition of peak balances in respect of loans secured from directors, the respondent number one, here it is faceless assessment circle, it relied upon the three decisions. This is the interesting part. Those three decisions were not there anywhere. Bombay High Court said, quote, the judicial decisions relied on are completely non-existent. In other words, there are no such decisions at all which are sought to be relied upon by the respondent. It is for the respondent to show from where such decisions are fetched. In this era of artificial intelligence, one tends to place much more reliance on the results thrown open by the system. However, when one is exercising quasi judicial functions, it goes without saying that such results are not to be blindly relied upon, but the same should be duly cross verified before using them. Otherwise, mistakes like the present one will creep into that order. That is what, close the court. That is what Bombay High Court said. Bombay High Court, on this basis, quashed the assessment order because it violates the principles of natural justice. The reply was not properly considered. Decisions laid on were not there, not at all there in any of the uh, High Court sites or in the reported judgments, books, journals. So it quashed the assessment order, notice of demand, and the notice issued for levy of penalty. My comments, I really appreciate the Bombay High Court in this matter. Why? Generally, when you go to the High Court after filing an appeal, you will not be, even before you stand up for speaking, your case would have been dismissed. They will say, no, 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 whatever submissions you have, you go and submit before the authority. You have filed an appeal, how can you exercise writ petition? How the court can exercise writ jurisdiction? No, 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 you get out. No, we are dismissing it. They will not even hear you. They will dismiss, and they will say the famous saying, one person cannot ride two horses at the same time. Once you have filed an appeal, you filed and you exercise your right, statutory right. No, so don't come. No, finish. They will finish the matter there itself. But Bombay High Court heard the advocate and then understood the gravity of the situation and then passed a very good order. This is my view. First point, because there are some cases, which I have seen in my personal experience, that a writ petition is necessary, it's a must. What we generally do is we file the writ petition and then we file the appeal, saying that we have already filed the writ petition, and to save limitation, we are filing this appeal. That is what we generally do. This person has reversed it. So in this case, definitely the High Court, the Bombay High Court is to be appreciated, because they have taken a prudent, I can't say prudent, they have taken a correct view. That is what I can say. Second thing, second point, second comment. Nowadays, anything you ask, immediately artificial intelligence is relied on. You say any judgment. Those days, my senior used to maintain a very big book, notebook, big one, like the accounts register. So he will note down methodically, systematically, continuously, sincerely. He will read all the judgments, and if it is some section 156, under section 156, he will note down all the judgments, Supreme Court, High Court, everything will be there, with 2 lines, what the judgment says. Nowadays, nobody reads. Everything you type, immediately it throws some 10 judgments. 100% it is a very useful tool. You cannot, I challenge anybody. I challenge. Nobody can read all the judgments from all the courts. It's only limited to Supreme Court and the High Court. I think I am the only fool who reads at least 3 or 4 High Courts relating to income tax, customs, and other cases, and Supreme Court, almost all judgments. Because nobody has got the time. That is the question of time to read. So, I personally feel my senior's method of reading each and every judgment is very important before relying upon. God given intelligence is more powerful than man made intelligence. One cannot avoid artificial intelligence, but because it is quicker, very quick in throwing the results, but you cannot totally rely upon. That is whatever Bombay Court said is correct. The third one is, the natural thing is, artificial lemon juice is used for drinking. You go and ask for a lemon drink in the hotel, they will give you artificial lemon juice. You drink happily. And when you finish off everything you are eating, what they give you is warm water with natural lemon. Natural lemon juice is always used for washing your hands. That is the reality of life. Thank you very much. Have a great evening. Bye.